Thank you for joining today's session. Today's session is entitled Reasonable Accommodations on the Job, Title I of the ADA. Your presenter today is Shelesha Taylor. Ms. Taylor has been an advocate with dLCV since 2014 and has over 15 years of advocacy experience in vocational rehabilitation, special education, educational law, employment law, and juvenile justice. She is also a PhD candidate pursuing a doctorate in educational law. Before we get started, there are a few housekeeping rules that we'd like to address. Speakers, please remember that we're using live captioning and interpreting services. When you first introduce yourself today, whether it be as a speaker or a participant later on, please include a physical description of yourself and your preferred pronouns. And I should say that I forgot to say, hello everyone, my name is Stephanie Sabatini. I'm a disability rights advocate with dLCV and I will be moderating today's session. I am wearing a light pink shirt, have blondish brownish hair, and my pronouns are she, her.
Awesome.
When you introduce yourself today, this will help provide context for all attendees and will help the interpreters and captioners locate who is speaking on the screen. Also, please stay muted at all times unless you are a speaker, and please hold all questions until the end. We do have a chat box that will be monitored by the moderators. The chat box is used for questions only or as directed by the session speaker. At the end of each session, moderators will select some questions from the chat box. If your question is chosen, you may take yourself off of mute and ask your questions, or simply type your question in the question box. And with that, I will happily turn it over to Ms. Shelesha Taylor.
Thank you, Stephanie. Like Stephanie said, my name is Shelesha Taylor. I am a disability rights advocate at the Disability Law Center of Virginia. So a brief visual description of myself. Keep in mind, this is coming from an individual with a visual impairment herself. So I guess I could just describe myself as looking very similar to Beyonce, maybe. I don't know. Okay. No, but seriously, I am an African-American female, fair-skinned African-American female with braids. So I guess I have so much to share with you guys today. So I guess we can get started. So I'm going to do a little background on the ADA first, and then we'll get into the meat and potatoes of reasonable accommodations. But the Disability Law Center of Virginia's mission is to advance independence, choice, and self-determination, protect legal, human, and civil rights, eliminate abuse, neglect, and discrimination of people with disabilities through zealous and uncompromising legal advocacy and representation. So I'm sure you guys already had an introduction of dLCV, but I think it's always important just to share our mission as we begin doing trainings. So there are 4 anti-discrimination protections for people in employment. We have those protections under the Virginians with Disabilities Act. So if you work in Virginia, you are protected under the Virginia's Disability Act, VDA. You also have the protections provided by your employer. You have the Rehab Act of 1973, and we'll talk a little bit about that. And then, of course, the Americans with Disabilities Act. Section 504 of the Rehab Act of 1973 prohibits discrimination against individuals with disabilities in any federal program or activity receiving federal funds. So that would be, federal government employees, anyone working that receives any federal funds. So they would be protected under the Rehab Act of 1973. So I guess if we're going to talk about Americans with Disabilities Act, we would need to know what is an individual with a disability. It is a physical or mental impairment that substantially limits one or more of the major life activities of an individual. So in 2008, they expanded the definition of disability. As you know, well, you may not know, the Americans with Disabilities Act was enacted in 1990, and they found that a lot of people were using the excuse that individuals didn't have a disability, so they don't have to provide accommodation. So what they did was in 2008, they expanded the definition. They pretty much loosened the definition of disability, which is this definition. All you need is one or more limitation that substantially limits one or more major life activity. As of September 2021, the US Census Bureau reported that approximately 61 million, 12.8, and some people say even as high as 25% of adults in America met the definition of disability under the ADA. So if we're looking at 25% of the population, that's a huge figure, that's a huge number. It represents a significant portion of the population and includes individuals with various types of disabilities. First, both visible and invisible. And we'll talk a little bit more about that in one moment. But I do want to talk about how disability impacts all of us, whether we have a disability or not. But just some statistics, 12.1% of adults have a disability, a mobility disability, with serious difficulty walking or climbing stairs. So that's a significant amount of people who have mobility disabilities. We have people who have cognition disabilities, impairments, and that's about 12.8 people of 12.8% of Americans who have difficulty concentrating. That would include like ADHD or other cognitive impairments. About 7.2% of adults have an independent living disability, which includes individuals who have, trouble doing errands alone, getting around alone, maneuvering the community alone and independently. 6.1% of adults are deaf or have serious difficulty hearing, which is, it's a good amount. We have 4.8% of individuals who have severe vision loss, or are blind. And these individuals cannot be corrected even when wearing glasses. 3.6% of adults have a self-care disability with difficulty dressing or bathing. So that's just a breakdown of, what the type of disabilities that are out there. Of course, again, some of them are visible, some are not. But even if the disability is invisible, they can still be considered an individual with a disability protected under the ADA. Okay, so invisible disabilities. Many disabilities aren't invisible, like I stated. Some examples include brain injuries, mental health. We have certain medical conditions, learning disabilities, some visual disabilities, and some hearing disabilities are all like just, it's not an exhaustive list, but just examples of disabilities that can be invisible, which means you can't just look at that person and tell that they have that disability. Okay, so the congressional purpose of the ADA, why did they even develop an anti-discrimination law for people with disabilities? They wanted to provide a clear and comprehensive national mandate to end discrimination against individuals with disabilities and to bring those individuals into the economic and social mainstream of American life. So that's just a lot of words to say we want to be inclusive. Inclusivity is super important, not just in employment, but in the community as a whole. But the main purpose was employment, well, in part employment, and just to make sure that we're being inclusive of people with disabilities. They also realized that SSDI and SSI and related programs cost tens of billions dollars annually. And if we could bring people into the workforce, if we could bring them into the community, there may be, we may be able to save some money. We may be able to allow those people to be independent and to be able to contribute to their society. They also learned that 82% of people with disabilities said that they would rather work than receive government assistance. So the barriers are external. And if we could kind of address some of those external barriers, then we may be able to, again, be more inclusive and then allow people with disabilities into the community and into the workforce. Okay, so interesting fact, disability is the one minority that any of us can join at any given time. So you can, be just able-bodied one moment and the next moment not be. So with that said, we all want to make sure that we're caring, because any of us can be in that minority at any time, and our loved ones can be too. So it's important to make this information available and to know it and to be able to advocate for yourself and for your loved ones. So who else is protected? So we know that individuals with disabilities are protected. We know the definition of disability, but who else is protected? So retaliation is prohibited against non-disabled persons who oppose unlawful discrimination against individuals with disabilities. Also, those who associate with or provide care to those individuals with disabilities are a protected class. So I like to use the example, for example, if you have an individual who applies for a job and their child has a disability, and the employer says, I don't want to hire this person because their child has a disability and they may miss too much work, so let's not hire them. They would be a protected class under the ADA. They don't have to have a disability. The fact that their child has a disability, you can't discriminate against that mother who has a child with a disability just because you think that child's disability may affect, maybe attendance or whatever. You can't discriminate against that person because they take care of an individual with a disability. It is unlawful for a covered entity, we'll talk about covered entities, exclude or deny equal jobs or benefits to, or to otherwise discriminate against a qualified individual because of a known disability of an individual with whom the qualified individual is known to have a family, business, social, or other relationship or association with. So again, that example with the mother whose child has a disability, it's unlawful to discriminate against her because she has a relationship or association with a child or an individual or a family member with a disability, a spouse with a disability. Okay, so who is not protected under the ADA? The ADA does not cover environmental, economic, or cultural disadvantages, nor age, sexuality, compulsive gambling, nor having a prison record. Now, I'm not saying that those people are not protected. I'm just saying they're not protected under the Americans with Disabilities Act. There may be some other anti-discrimination laws for those cases. I'm going to briefly go over the 5 titles of the ADA. We're talking about Title I in this one, but just for a FYI, just a brief overview of the 5 titles. So of course we have Title I, which is employment that prohibits discrimination employment. We have Title II, public services. It applies to state and local government entities, prohibits discrimination based on disability in public services, programs, and activities. That would be like public libraries, public transportation, public education, and just basically access to public facilities. Title III, we have, those are private entities. Those have to do with private entities such as hotels, restaurants, retail stores, and private transportation services, for example. Now we have Title IV, has to do with telecommunications, such as access to telecommunication services, or individuals, for individuals with hearing or speech impairments. It requires telephone companies to provide relay services for people with those communication disabilities. Okay, and lastly, we have Title V, which is the miscellaneous provisions. It provides technical assistance and stuff like that. Okay. So when can an employee request an accommodation? One, during the application process, while performing the essential functions of the position, and then 3, when ensuring enjoyment of equal benefits and privileges of employment. So the application process. Reasonable accommodations during the application process can take many forms. Some examples that may be needed during that hiring process include ensuring that people have written materials in accessible formats, large print, braille, any type of electronic format, even audio tape. Providing readers or effective communication, ensuring recruitment, interviews, tests, and other components of the application process are accessible and held in accessible locations. Providing or modifying equipment or devices. Adjusting or modifying application process, procedures, and policies are just a few examples. Keep in mind, this is not an exhaustive list, but these are just examples of things that may be requested during the application process. For one example that I've seen is like when you have a time test, a lot of these places are doing like applications and you have this time test, requesting extra time to be able to take the test. You don't have to be employed by them, but, to be able to have equal playing ground or level the field for an individual with a disability, it's totally okay to ask for extra time so that you can complete that test that is timed. Okay, so performing essential functions of the job. What is a reasonable accommodation? So now you have the job, right? And now you want to perform the essential functions of the job. To request that reasonable accommodation after you get the job. So these are some of the things you can do. Well, first, I guess, let me explain the legal definition of reasonable accommodation. And it is any change in the work environment or in the way things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. Okay, that's the legal definition. Plain language is just to modify policies, procedures, just to be flexible, allowing for accommodations, just changing the policies if necessary, or changing the way things are customarily done, just so that it can make it accessible for an individual with a disability. So let me, I want to talk about some of the monumental court cases that we have gone through with the ADA. I just have 2. The first one, and I'm using pseudonyms so that I don't name the airline and the exact case, but some of you guys may realize the case, but that's fine. But the pseudonym, okay, we have XYZ Airline, right? Against McMillan. And so McMillan had a back injury where she needed accommodation, but instead of discussing that, the employer discussing that with her, they made the knee-jerking decision to terminate her. And so this was monumental because it stressed the need for the interactive process. Interactive process, what is that? That's basically where the employer has to engage in what they call the interactive process, discussing what possible and reasonable accommodations could be provided, what could be needed, and just discussing, just having that dialogue and discussion with the employer and employee. And so in this case, this individual, we're going to call that person McMillan, who had the injury, was terminated, and then the Supreme Court determined that again, wanted to emphasize the importance of the interactive process, and they determined that they ruled in favor of McMillan, again, pseudonym. So another example, we have Robinson, pseudonym, against PMS Corporation. So Robinson had been diagnosed with multiple sclerosis, where she needed reasonable accommodations. And this one was just blatant, like she became disabled, developing multiple sclerosis. The employer said, no, we can't keep her. And so she sued under Title I of the ADA, and she won. And then again, she had, just a little background, she had went on medical leave due to her multiple sclerosis, and as a result, they fired her. And so the Supreme Court ruled in favor of Robinson, stating that individuals with disabilities are protected from discrimination, not only in hiring and promotion, but also in terms and conditions of employment. So actions such as termination based on disability can constitute discrimination under Title I of the ADA. So that was pretty much blatant. She became disabled, she went on medical leave, they fired her, and the Supreme Court said, no, we don't do that. Okay. So additional information to note about Americans with Disabilities Act. Not all cases brought under Title I of the ADA result in formal litigation. Many cases are resolved through informal negotiations, settlements, or alternative dispute resolution methods. The outcomes of these cases may not be reflected in formal court rulings. So, and that's more likely than not, that these cases don't always go to court. A lot of times, again, they're settled through more informal means, and that's okay too. But just keep in mind that if you're looking up court cases, or, it's not always that. It's not always a court case. Equal employment is not, however, eliminating essential job functions. That's the whole point of reasonable accommodation, so that you can perform those essential job functions. Lowering production standards apply to all employees. Again, the whole point of reasonable accommodations is so that you don't have to lower production standards. It's so that they can keep up with their coworkers. Providing personal use items. So, things that are needed for the home, that's not the purpose of the ADA. It's employment related accommodations. Excusing violations of uniformly applied conduct rules and stuff like that. Those are all not what the ADA is about. What are essential functions of a position? So going back to the definition of the ADA and Title I, we have the employee has to be able to perform the essential functions of the position with or without accommodations. So it is the minimum required duties and abilities necessary to perform the tasks of a job with or without reasonable accommodation. So without a reasonable accommodation, I may not be able to do it, but with a reasonable accommodation, I can. So then at that point, I'm able to perform the essential functions of the position. What employers are covered under the ADA? Private employers of 15 or more employees and state and local governments are considered to be covered employers. Some examples include public schools, police and fire departments, public libraries, and public parks and recreation. Those are just some examples. So I do need you to please note that the ADA does not apply to federal government employees, which we discussed earlier. Federal government employees are protected under another anti-discrimination law, which is the Rehab Act of 1973, which we discussed earlier. So accommodation basics. So accommodations must be effective. It does not have to be the best accommodation. So the example I like to use is I may need headphones, but they might not be Apple Beats, you know? So it may not be the best, but as long as it's effective. But only improve employment-related barriers. So again, if I need a special cutting board at home, they're not required to do that for me. It only applies to work-related accommodations. Personal device is not required. Again, things that are maybe needed at home. Employer not prevented from providing extra accommodations. If they like, you don't want to overdo it, but yeah, they're not prevented from doing, providing extra accommodations. The individual must let the employer know that they need an adjustment or change or adjustment at the office or work, and let them know that it's related to a medical condition. And there's no need for them to use special legal terminology. They can use plain language, and they don't have to say the word ADA or Americans with Disabilities Act or reasonable accommodation. All they need to say is, I have a disability and I need, a change in whatever it is that they need. When the disability, and by the way, going back, it doesn't have to be in writing, but we strongly suggest, or I strongly suggest, it be in writing, because something I hear often is, if it didn't happen in writing, it never happened. So definitely want to do that in writing. If the disability is not obvious, the employer may ask the individual for reasonable documentation about their disability and functional limitation. If there are two possible reasonable accommodations and one costs more or is more difficult to provide, the employer may choose to do the one that is less expensive or easier to provide. And that's okay, because as long as it's effective. Again, I use the whole Apple Beats, example. It may not be top tier, top of the line, but if it does the same thing and it provides the same accommodation, then the employer can choose that one. Some resources for you guys to consider as you navigate accommodations and working with your employer. Should you have any questions about your rights about the ADA, Title I of the ADA, or if you feel that you are a victim of discrimination under Title I of the ADA, you can contact the Equal Employment Opportunity Commission. Their phone number is 800-669-4000. Don't ask why I know that by heart, because I do. We get tons of calls on that on a regular basis. Another resource that a lot of people don't know about or don't utilize probably half as much as they should is the Mid-Atlantic ADA network, 800-949-4232. They're a great resource because they provide technical assistance over the phone, and they actually answer the phones. So they're a great resource as well. One that I just thought of that I didn't put on here, and if you guys need this information or someone wants, there's the Job Accommodation Network, JAN. They are also a good resource, so you could look them up as well. And so I guess what I'll do is turn it back over to Stephanie, because I'm sure we have some stuff in the chat, probably some questions from folks that may have.
Let's see what we have. Let's see, it looks like Elizabeth Horn asked, when is the best time to disclose you have a disability during the application or hiring process?
So, people get that a lot. Like that is really up to the person, but I hear different answers to that. Some people don't want to disclose their disability during the application process, and you don't have to. If you feel you need an accommodation during the application process, then by all means go for it. But you don't have to. Some people, 32% of the people who have disabilities don't disclose their disability. That's significant because of fear of stigmatism and whatever, but a good significant amount of people, of workers. So that probably means that tells me a lot too. That probably means we all work with people with disabilities and probably don't even know it. So again, you may not ever disclose your disability. It may be a time where you actually need it, and then at that time you can request a reasonable accommodation. So it really just depends on the person, when they feel comfortable, when they feel they may need an accommodation or a change to the way things are customarily done in order to be able to fulfill those essential functions.
Perfect. And it looks like Elizabeth provided the website for JAN, Job Accommodation Network, in the chat for everyone. So thank you, Elizabeth, for doing that. It doesn't look like we have any other questions in the chat. If someone has a question, please feel free to take yourself off mute and ask the question, or drop it in the chat, and I will be happy to read it aloud and ask it. Elizabeth also says, if you know you are going to need an accommodation to perform the essential duties of the job, should you ask before or after you are hired?
So I would say at the point in which you need the accommodation. But that's, again, up to the individual. But I would say at the point in which you need the accommodation. So if there's something that you think that an assignment you think you've been given and you're unable to do it without an accommodation, that would be the point in which you're like, oh, pump the brakes, let me ask for some help. Let me ask for an accommodation so that I can fulfill my essential job functions.
Perfect. Thank you, Shelesha. And then Andrew asked in the chat, can working remotely be an accommodation for psychiatric disability?
So accommodations can come in many forms. And so I hate to say this, but it depends, That's always like the answer, and that's what I feel like, in my opinion. It's always the answer in the legal world. Like, it depends. So I would say call Job Accommodation Network, because again, they're the gurus of accommodations, and they may be able to help sift through. Part of knowing and being able to advocate for yourself is knowing what you need and being educated on what it is you need. And sometimes you don't know what you need until you get to the point where you're like, oh my gosh, I might need help with that, or I might need an equipment or technology to help me get through that. So sometimes you may not know what it is you need. And part of navigating and advocating for yourself is being aware and being educated about what it is you may need. Sometimes that comes in time. Sometimes that comes a year after you've been employed with an employer, you know? So sometimes it's not the day one where it may be time before you even know how to navigate what it is you need or that you even need an accommodation.
Elizabeth also noted that Jan also has disability-specific accommodation options that can provide examples of what's reasonable.
Yes, absolutely. Thank you, Elizabeth. They're a great resource. And I'm sorry I didn't put it on the PowerPoint, but hopefully if someone, views this, it came to me as I was talking, as I was running my mouth, I thought about it. I'm like, oh my gosh, Jan is a great place to go. So yes, they're a great resource as well to be able to navigate some of those possible accommodations.
And then Andrew asked as well, do the same accommodations apply to disabled students in higher education? The same accommodations and protections?
So that is actually a really good question. So when we talked about the different titles of the ADA, and that's why I'm glad that I touched on all of them, so you do have rights under the ADA. It wouldn't be under Title I though. Title I is employment. And I'm assuming he's asking as a student, not as an employee of the higher ed or of a college. So as a student, it depends on whether the school is a private school or a public school. And if they're a public school, remember we talked about Title II of the ADA. And if they're a public school, you would tap into Title II of the ADA and you would be protected under those rights. Now, today we only talked about Title I. So yes, you do have rights under Title II. This presentation wasn't about Title II, but we could, we have those resources to be able to tap into more detail. But yes, you would be protected under Title II. And if it's a private school, you would be protected under Title III of the ADA. So yes, you do have protections, but it just wouldn't be under Title I.
Just to note, Shelesha, he did comment that yes, he was referring to as a student. So
yeah, okay, perfect. Great.
And then looks like Felicia Smith asked if a person's disability prohibits them from performing several essential duties of a job when not hiring that individual be considered discrimination. How does an employer ensure that they are following the ADA in this kind of situation?
So in order to be a qualified individual under the ADA, qualified means that you can perform the essential functions. So we talked about essential functions. I guess I could have went more into qualified individual. A qualified individual would be an individual who can perform the essential functions of a position. Now that's with or without accommodations, right? So if I wanted to be a truck driver and I don't have I can't drive, I don't have a license, and I don't have accommodation that I can think of that would help me be able to drive this truck, then I'm not a qualified individual under the ADA. However, if I could magically figure out how to drive a truck and be able to do those essential functions with accommodations, now I'm qualified because I can perform those essential functions. And now I would be covered under the ADA. I hope that makes sense. So you have to be a qualified individual to be, and qualified means you have to be able to perform those essential functions. And that gets like really sticky too, because some jobs say that certain duties are essential to the position, and sometimes they're not really. And we're being honest. Sometimes, and so that gets into a whole nother issue, but determining what percent of that job requires what percent of that job is required to be able to fulfill that position and be able to do the essential function. So If you have, again, I'll go back to the truck driving position. If 95% of the job is driving the truck, and you can't, that's an essential function of that position because it takes up a significant part of that job. But if, I don't know, I can't think of something, but if there's just a small portion of that job, then it's not really an essential function. But even if you can, if it's a small portion of that job and you're able to get an accommodation to do it now, and then it isn't, and you have determined it is an essential function, and that accommodation allows them to do that function of that job, that again makes them a qualified individual.
So Shelesha, if I could, I just have a question. As a person with a disability myself, with regard to the truck driver example. So say, for example, that they can drive the truck, however, they need adapted equipment to do so. Does the employer have the right to say, oh, well, we can't provide that, you can't be hired here, or how would that work?
So the one out way they have, one of the ones that I'm thinking of is undue hardship. I didn't talk about this much because this could be a whole conference. We could have a 2-day conference on Title I of the ADA, if we're being honest. But one of the things that an employer can say is this accommodation is an undue hardship. So that depends too, right? Like if I work for a Fortune 500 company and I say headphones are a hardship to me, that's probably not. But if I work for an employer who makes about $10,000 a year, then that may be a hardship. You know what I mean? So it really, again, back to my legal term, it depends. Because they can claim undue hardship, but again, that depends on the employer, because some employers, it may be an undue hardship, and some employers, it may not be an undue hardship. So again, that hate to say it, but it depends, you know, because not everyone has the same resources. Not every employer has the same resources. So, but that is a way out of, you know, providing that accommodations, because if it's too much of an undue hardship, they can claim that.
Absolutely. Thank you for clarifying.
Yeah.
It does not look like there are any more questions in the chat. Does anyone have any questions and would like to come off mute and ask them, or drop them in the chat? I'm happy to read them.
Yeah, this has been a great discussion. Thank you guys for the questions. They were all really, really good questions. Okay. Again, you know, the Disability Law Center of Virginia is always a resource. We are available Monday, Wednesday, and Fridays from 8 to 4:30. We take on duty. You could also, best way to reach us is through our Get Help form on the dLCV website, www.dlcv.org. Or you can reach us by calling 800-552-3692. What is the number?
You are right. It is 1-800-552-3962 for toll free, and 804-225-2042 for anyone local to Richmond, Virginia.
Thank you, Steph.
We also have a wonderful Get Help form online, and you can access that through www.dlcv.org/gethelp.
Awesome. I'm glad I didn't go over my time. I talked really fast because I wanted to get all that information in, but you guys have some great resources, have some great questions, and you guys could always feel free to reach out to us on an individual level if you need to. All right, all done?
Thank you, everyone.